So good evening. Welcome to Elder Law Tips and Traps, and there are a lot of traps out there, and I'm hoping to give you enough tips here. A little bit about me. I can't believe this. This November I'm celebrating my 40th year as an attorney. All I do is elder law, estate planning, and estate administrations. That's basically probating a will. That's all I do. The most important memberships I have now are the National Academy of Elder Law Attorneys. They have an excellent national organization, and our Massachusetts chapter is really wonderful. A lot of current, we're always kept current because of these memberships. And also a member of the Greater Springfield Estate Planning Council and the Pioneer Valley Estate Planning Council. For many years I've taught at HCC. They charge about $87 or $89 for 6 hours of material over 3 Monday evenings in a row. If people really want to dig in, this will be kind of an overview of what you'll get the idea from my class when you hear my presentation tonight. So I can't help myself. I've got to start with what I call the Big Five. I've had people like Google that. I use a lot of phrases. They're not in Google land yet. And I literally do that, the Big Five, all the time. And so here's the list. Now, the top one, people are familiar with the will, but the other, and the bottom one, a homestead, that's really important. I want everybody to have a homestead on their primary residence in Massachusetts. A homestead will save the house if you were to get sued by a judgment creditor. They can't take your house. It's an amazing thing we have in Massachusetts. You can check for yourself by going to masslandrecords.com and click on the county where your primary residence is located, and then type in your address, and you can see what's recorded on your property. The 2 through 5 there, they die when you die. The person who signs these documents is called the principal. When the principal dies, they die. Why are they so important? Because we avoid going to probate court once. I used to be a litigator for 20 years of my career. I was in court like every day. And I did people who didn't have a durable power of attorney before they lost mental capacity. We had to do a conservatorship for them. And that goes on and on. It's terrible, it's stressful, it's expensive for the families to do that. The healthcare proxy avoids a guardianship. In those 2 documents, you name an agent for the durable power of attorney. If a person becomes unable to know what they're signing, the agent they appoint in the durable power of attorney can be them without going to court once. The healthcare proxy avoids if a person becomes unable to decide or communicate their healthcare decisions to their physician, their appointed agent can do it for them without going to get a guardianship. It's a wonderful gift for the family. The advance directive is also known as living will. That's very important to avoid the Terry Schiavo situation. If anyone remembers her, she was kept alive artificially for over 10 years, I forget, 12 years or so. And the HIPAA release is very important for allowing your healthcare proxy to have access to your medical records. Now, the will, does anyone know what happens if someone dies without a will? And what happens? It's the law of estates, of testate succession. It's the family tree. I just have someone I know in Western Massachusetts. She just inherited $4 million from her, at least she knew him. Usually it's strangers who inherit this. Her first cousin in New York State. He ran out of beneficiaries. He died when he was 94. He named his domestic partner number 1 and his best friend number 2, and they died before him. He forgot to update his will. So we're having the big genealogy thing going on in New York State coming up soon. But long story short on the genealogy, it goes up to his grandparents and drops down to you find someone alive, and she's the first cousin, the last one at age 92. If she had died before, it would have kept going. Anyway, in a will, you name who you want and who you want in charge. It's not subject to the law of intestate succession. So that's the Big Five. So now turning to elder law specifically. When a spouse has dementia or creeping dementia or forgetting, issues with memory, like early stage, middle stage, that's a very important time to meet with the elder law attorney because for those bullets here, the first thing is, the first piece is that first bullet up there. The person who has dementia probably has, they often do, most of the time, they really do have sufficient legal capacity to sign some of these Big Five documents. And they are very important. We want to catch it before they lose all their marbles, to not be medical or legal right here. But we want to make sure if they have a little bit of competency left, we can still catch their signature on really important documents to keep the family out of court. That's really the heart, the big reason for the big five. Now, the other piece that is often forgotten is the second bullet, and that's the first paragraph. The first bullet for the well spouse, the spouse who doesn't have the dementia issue. The well spouse, first of all, he or she has to sign new estate planning documents in general, because let's say it's the wife who's the well spouse in this example. Her husband is the one who's down to his final marbles, or maybe he has complete dementia at this time. The well spouse doesn't want, probably in her documents she's already prepared, let's say 20 years ago she named her spouse to be her agent everywhere. Well, we have to change that. He can't do that anymore. But the piece that's very frequently overlooked is this issue. Let's say that the husband, we're going to be talking about Medicaid. That's the program we call in Massachusetts Mass Health. Let's say we do a good job and we get Mass Health to pay the nursing home bill, which is around $12,000 a month. So that's a very important thing to do, is to get Mass Health to pay the nursing home bill. So he has to be under $2,000 to qualify, but you'll see his spouse, we'll just keep the same hypothetical. Let's say it is the husband again. The wife's at home. She can keep more money. We'll get up to that. You'll see that. But let's go to the husband. He can only keep under $2,000. So let's say the wife didn't think about this important step I'm talking about, and she dies first. We look at her will and the law of intestate succession would give it to her husband. Now her husband gets the inheritance. Let's say she had $100,000. Then the husband who's in the nursing home gets $100,000. Oh, he's over $2,000. He loses his Mass Health benefits. Then all the $100,000 goes to the nursing home until he spins down at the rate of $12,000 a month, till he spins down to under $2,000. But if the wife ahead of time had done a new will with a testamentary trust built into it, it diverts the money and shelters it for the benefit of her husband, and it's not managed by him. He can't do that in this hypothetical, so it's usually a child or a niece or nephew or best friend, someone who would be the executor, is usually the trustee of this trust. So in this example, that $100,000 would go into this testamentary trust, and the husband's Mass Health benefits would continue. So I know it's a little bit technical, but it's a really important step. Yes?
If both spouses are legally competent,
all the will is doing is changing titled property from the decedent, the person who died, to the living beneficiaries. So if you, let's say it's Mrs. Green. When Mrs. Green dies, she has a bank account of $100,000 only in her name. The only way to get it to the living beneficiaries are to probate her estate, and hopefully she has a will which tells us exactly who gets it without doing a family tree and all of that. That's what a will does. It's designed to really move the property very quickly, and that it's in and out. We close estates 1 year, 1 day from probating her, from her date of death. A trust, I call it a piggy bank. It can hold money and other assets, real estate, even retirement benefits, and dole it out. Like if the people have young grandchildren, it's paid out over time. There's a trustee who handles the assets in the piggy bank. So they're very, very different from each other. The will just drives the property, just directs it to go from the decedent's name, the legal title, to the living beneficiaries. The trust, we still have beneficiaries, but we have a trustee who manages it over time. And that avoids probate completely. Whatever is in the trust avoids probate. Yes, back there, we'll get a mic to you.
How does the homestead provision play into this?
It doesn't. It's just in its own world. If you were to get sued, like if a person has an automobile accident and it's their fault and there's a judgment against them and their auto insurance doesn't cover the whole judgment, they can't go after the house if that person who drove the car who caused the accident had a homestead recorded. So we can do all these other things. But to be more technical, when I do a new life estate deed, we do a new homestead. Every time we do a new deed, we need a new homestead. So let's continue, let's drive on through this. So this is I never met her, but I get this lady on the phone, And she says, the first thing she says to me, calling a lawyer that she didn't know me either, and she said, my CPA said to talk to you that you know this stuff. He's thinking maybe I need an annuity or something, but what do I do with my barn money? She didn't give me any facts. Like, what do I do? She just wanted me to answer that question. What do I do with my barn money? I had no idea what she was talking about, and I finally got it with questioning, gentle questioning. I finally learned the facts. Her husband was already in a nursing home. She sold her barn for $10,000, so it wasn't talking about $1 million here. And I said, what else do you have? What do you own? She said, $50,000, and I don't want to lose my $10,000 barn money. I go, oh, here are the numbers. So this is a very important number here for everybody to know. She had no idea she could keep her home, her whole farm, adjacent property. We call it curtilage. Like, we can keep the primary residence. It's called non-countable. We'll get to that. And another $123,600. So I said, keep the barn money. You're fine. You're only at $60,000 here. So this is one of the reasons that drives me to speak before various groups and teach at HCC, because there's so many people really suffering out there because they don't know these rules, which hardly anybody knows, because it's so complex. It's such a specialized area. So what can be kept by the community spouse, that's a spouse at home if a person is married. They can keep the home, the $123,600. The spouse in the nursing home keeps $2,000. And then the other non-countable assets include one automobile, et cetera, But notice that one on the bullet there, just above I call it the magic numbers here, because that's when we get under those magic numbers, that's when Mass Health will pay the nursing home bill. So when someone's already in the nursing home, we're getting down as fast as we can through other techniques you're going to learn about today. But where it says assets needed for support, this year, my client she was the community spouse, her husband was in a nursing home, and she had a primary residence. That's easy, that's non-countable. She also had an apartment building worth $600,000 that I was able to save for her because we proved to Mass Health that she needed the rent from the 3 renters in the 3 units. She needed that income for her support. And that gets overlooked sometimes when people on their own or trying to fill out these Mass Health applications. We can keep additional assets if we can prove to Mass Health they need it for support, and she needed this rental income. So that's a very important bullet. I put a little star next there if you're taking notes here. So a next big question I get is, it looks like the wife here, so I'll just keep the same. So they're worried about, oh, my husband, I just saw one yesterday. The husband had the big pension of $4,500. The wife had the Social Security of $600. I see that all the time. So if the husband goes in, the rule is the income follows the husband and Mass Health makes up the difference. And that's very frightening when the spouse at home who doesn't have the income learns that. So I am able to get this word out here that the spouse at home, it's a wife in the nursing home now, the husband at home can keep all of his income, plus if he's under these magic numbers here, it's about income now, we really do call it the minimum monthly maintenance needs allowance, there's no easy way to say that, or the maximum. So the spouse at home can keep their own income and then grab some of the income from the spouse who's in the nursing home, so they total between these 2 numbers. Now, usually that is enough for the spouse at home, but if it's not, and we can prove, we don't mean luxuries, I mean the basics here. If they need more than that, we just ask for a fair hearing and appeal it. This is something we elder law attorneys get all the time, where something like, my CPA said it's okay, which for years it was $10,000 a year per beneficiary, and it's been creeping up. Last year it was $14,000. This year it's $15,000. It's okay to give $15,000 per year per beneficiary. That's an impermissible gift as far as Mass Health is concerned. 2 rules. Rule number 1, make no gifts 5 years before you might have to apply for Mass Health benefits. That 15,000 per year is not an exception, and that's what gets people in trouble so frequently. That's totally unrelated to Mass Health. That's only about estate and gift taxation, which that's not our topic today. Just know, no gifts. Now, there is a minor little exception that I have to say, because some people know about it and they bring it up. Yes, the exception is on the slide. It says if we can show a pattern of giving, like for example, I have clients who give to the Greyhounds or their church. They do have some regular gift that they've done for 20 years, and it's not some way to avoid Mass Health, to avoid paying the private bill for the skilled nursing home. So, but I usually don't see that very often. The other gifts are very serious. Like they say, well, I helped my daughter out. She went through a horrible divorce and she was desperate. Isn't that an exception? No, no. Or I want to give a lot of money to my church, or I did give a lot of money to my church. I had a caseworker at Mass Health tell me years ago when I was new to this, like 25 years ago, when I said, there's surely, to the caseworker, there must be an exception on the gifting rule because she gave her money to her church, and the caseworker said, let her church pay the Mass Health bill. No gifts. So now read rule number 2. Rule number 2 says, read rule number 1. Okay, really, this is a biggie. This is what we call the 5-year look back. Has anyone heard about that before, the 5-year look back? When we do a Mass Health application, it's around page 22. They say, have you or your spouse made a gift the previous 5 years? If we say yes, the gift has to be paid back. And when people are doing these gifts to their kids who are broke and desperate, no surprise, they don't have the money. If there's a gift within 5 years that can't be cured, they call it the cure, they don't get on Mass Health. It's a denial till you cure the gift. Medicaid, let me back up. Medicare is identical in all 50 states. It's health insurance for the elderly and the disabled. Medicaid is also a federal program, and they both were signed into law by LBJ in 1965. But Medicaid is different in every state, and it has its own name to remind everybody. So for Mass Health purposes, we have our own, we have to follow federal rules, but then we have our own set of regulations. Okay, this is another really important one. This is a true story too. I was doing a presentation similar to this one, and afterwards some people grouped around, asked their questions, and someone said, I'm making up this name, but someone said, oh, Mr. Smith didn't come to hear you speak, Attorney Jackson. That's so sad. And I go, why? They said, like 3 of them knew him. They said, he's so depressed. And I said, why? Because he's been paying his wife's nursing home bill at the rate of $12,000 a month for I don't know how long. And that made me sad, and I always want to bring this up every chance I get, because if Mr. Smith had come in to see me, I do these all the time, and I apologize for the small type. I'm glad I was able to do a handout for everybody. But we call it a Medicaid qualified annuity. So we could have taken, let's say Mr. Smith, the other problem that happens with people, Mr. Smith is just paying the $12,000. It's not the nursing home's job to see if he's paid down under his $123,600 he can keep. He's just paying the bill. He doesn't know anything about it. But let's pretend he still has, let's say, $500,000 left. We can, within 2 to 3 weeks, get his wife on Mass Health. How we do it? He keeps $123,600. His excess assets above that number, up to the $500,000 example I gave you, we do it as a single premium income annuity, and that the paperwork is signed in advance, and that premium of his excess assets, that one electronic transfer, goes to the insurance company, and the insurance company 30 days later starts his income. He gets income. We convert excess assets into an income stream. So Mr. Smith could have started getting these big checks, and he can pile them up, keep them in, and he can go above his magic number of $123,600. Because usually when we do this, he doesn't need this, the spouse at home doesn't have need for these big checks coming in. But how I calculate it is quite simple, because the interest rates have been so low. You divide by 60 months into whatever are the excess assets, whatever we're sending out. I frequently, have really big numbers that are coming in, like $8,000 a month for 60 months. So that's what we could have done for Mr. Smith. I had a client who I had told him about this for 3 months before he finally was worn down. He just didn't feel comfortable to do it for whatever reason. And he finally was just, you know, it's just very painful to see your life's work and all your savings go out the door that fast. So it's a really important tool to use, and it has to be done right. I mean, we have to do the paperwork right. We have to compute the numbers. So again, you would want to see a specialist, elder law attorney who's a member of JLaw to do this. Most people, when we're talking about Mass Health, they have a home. And so there's a lot of discussion around saving the home. For the spouse will be all right. Mass Health can't touch the house as long as if it's a single person and they're in a nursing home, they still can't touch their house. They can't not force to sell the house as long as the applicant, the person in the nursing home applying for Mass Health benefits, or a spouse if there is one, as long as they're alive and living in the house, they can't force to sell the house. Or a disabled, there are other exceptions too if they have an adult child who's disabled or someone who co-owns. There's some other exceptions, but the biggest one is the spouse. You might have heard about the lien. The lien kicks in if someone fills out an application. There's this weird little box that says, does the applicant intend to return home? Well, if someone's doing this on their own, they check the box, no, my spouse is never coming home. We check yes, and that avoids the lien. So, but the lien is not a big deal. After the death of the final person, if they're a married couple, I just call Mass Health, and within a week we get the lien released. It dies when they die. It's only there so the house doesn't get sold out from under Mass Health. I had a case where the spouse did later sell the house and buy a new house, and Mass Health picked up on that, and they wanted to make sure she had some excess money from the house that she didn't put into her new place, and they wanted to know where all that went, because they wanted all to go only for the surviving spouse. Again, no gifts. Before or after, no gifts. So what we can do to save the house, there are different techniques. So there's long-term care insurance, which is nice if people can afford it. It pays for home care, assisted living, and the skilled nursing home. It's a check that comes in every month. It's very helpful for families who can afford it. I'm surprised that Mass Health gives us a break on the house can be saved with a long-term care policy. This is a very minimal policy. I've never seen one this low yet. It only is providing $125 a day for 2 years, no less than 2 years. So I never see a daily rate that low. Right now, our daily rates are around $400 a day. So, that is a way to do it. But of course, as a lot of people know, if they get long-term care insurance, they pay every year until they actually use it, if they ever do. So then they pay for life. So there's a cheaper way to save the home, but that is one way because it has other benefits than saving the house. It's just that's a side benefit to save the house. There's a caregiver child exception I'm going to talk about, and a life estate deed. So these are the three, I'm going to talk about the final two tools to save the house. The caregiver child exception, this happens very frequently. You might even know someone in this situation where a parent, let's say it's a single mom, she's living alone, she's declining, and one of the children, let's say a daughter, is either between jobs or actually quits a job and moves in with mom. So if we can prove to Mass Health, it's only 3 things we have to do, and I'll go through them, then it's a permitted gift of the house. Mom can sign a deed giving her house to her daughter. If the daughter has lived with mom or any parent, it's only for a child of the person entering a nursing home. The child has to live with the parent continuously for at least 2 years. I had someone say, I have to live with mom for 2 years? No, at least 2 years, up to the point mom actually enters a nursing home. So if the kid has a fight with mom and moves out a month before, you're out of luck. You don't get a house. You got to go the distance, as I call it. So Here's how we prove it at the time of application, but I do it sooner too. I do the deed sooner when I know it's a slam dunk. We have to prove, here are the bullets, they've continuously resided with the parent, and they caught somebody. There was a case where they caught, I don't know how they did this, but Mass Health caught the daughter. She was actually living with her boyfriend. And then she was at mom by day, but not at with mom by night. You have to be with mom. I don't mean you have to be there every minute. I don't mean that. You have to, she, I guess, had another residence they picked up on. I don't know how they do. They don't like to tell us all their tricks. It's cat and mouse all the time. So the easy way, it's really a very clever, simple way to prove continuous residency. Voting record. On one page, we can show that the child continuously resided with the parent for at least 2 years with the voting record. So when I have caregiver children who don't vote, I say, vote, vote. It's so much easier than trying to patch it together. You would have to, here's my library card, here are my tax returns, here's this, that. It's just so much easier to vote, and then we have one page to prove continuous residency for at least 2 years, up to the point of actually entering a nursing home, the parent. And then the care is very important. We used to get away, in the good old days, we used to get away with just showing the child lived with the parent for continuously, but now there's a case that we have to prove that the child provided the parent with at least 2 activities of daily living, and that will show up in the third thing, the doctor's letter. And then I listed them, the ADLs, if you've heard about ADLs, eating, bathing, getting dressed, toileting, transferring to a bed or chair. Those are the ADLs, but I find the doctor's letter is actually quite easy, because if we're getting to the point, it is really a true thing. When a child lives with a parent, it really does skip the assisted living intermediate stage, and they really are sincerely trying to keep the parent at home. And they really do go beyond 2 ADLs usually by the time they just can't do it anymore, which is usually falls and incontinence is usually like where the saints just can't do it anymore. And so we get the ADLs. So these are the 3 things. We just need a copy of the birth certificate of the child. It only works for children. So people who never had children, we don't have this as a tool. It doesn't work for nieces or anybody else. And then the one-page voter sheet showing continuous residency for at least 2 years, and the doctor's letter. Because the idea of getting a house, Mass Health recognizes that these heroic children who are moving in and living with their parent for this length of time, they deserve a house, and they save the state a lot of money. The state pays an average of $6,000 to $8,000 a month when someone's on Mass Health. So the nursing homes like private pay, they're getting $12,000 a month. But Mass Health, that's still a lot of money for Mass Health to pay. So they're happy to let the kid have a house because they delayed the entry into a skilled nursing home. So now we're going to do what I call a reverse caregiver child exception. This happens naturally also. It's where, even though the regulation, when it was written, anticipated the classic of the kid moving in with the parent, but it works the other way too, where, and I see that it just unfolds in a natural way with families, the house is too big, the husband has died, mom really can't handle this house anymore, and the kid, even with a husband, but let's start with a simple example. Let's say it's a unmarried child who lives alone in her house. It makes more sense for mom to sell her big old house and move into the in-law apartment or some section of the house that the daughter has, let's say son in this example. So mom moves in with the son, and mom sells her house and buys in, because her house is non-countable. So let's say she sells her house. We get an appraisal of the son's house. She buys into the son's house, and the son gives a deed back. Now, what we have to do are get our numbers right here. We have to do an appraisal, because heaven forbid that mom paid an extra $1 to her son that was a gift. So let's say it's single son, unmarried son, and let's say his house appraises at $200,000, and mom pays son $100,000. Son's got $100,000. He gives a deed to himself and mom jointly. Mom's older. Most of the time, mom dies first, and then without probate, son has his house back, and we've saved $100,000. The title thing we need it to be jointly titled, because we never want to probate, and we're going to talk about this a little more with a life estate deed. We don't want to probate an estate if we can avoid it, because through probate administrations, that's when they get paid, Mass Health gets paid back. If you've heard, have any of you heard where people have lost a house to Mass Health? It's never during lifetime, it's through estate recovery after death. So if the son was married, then, and the appraisal, I gotta make my numbers easy here for me. If the appraisal said 300,000, then mom gives 100,000 and gets a third. So husband and spouse and mom jointly own their house together. And then that's not even to the reverse caregiver child exception. That is a buy-in that actually works to shelter all the money, or at least what we could push into this plan for mom's sale of mom's house. It's a great way to save that part of the money. Then now mom's living there with a child, so son and his wife don't have to wait for mom to die to get the house. If mom lives continuously with her son in the son's house for at least 2 years, all the way up to the point that mom enters a nursing home, if she ever does. So then at that point, it's a permitted transfer for mom to give her 1/3 back to son and his wife. So it's really 2 plans built into one. And I know this is a little complicated stuff, but the main thing, because I know I'm jamming your heads with a lot of information, is to spot an issue, even if I'm sure something can be done here. I just want people to try and reach out and learn, like the articles that Leslie mentioned that I post, and I put them on in the newsletter here. I also post my articles on my website, the ones I write here for this newsletter, and I hand them out to my clients, and I say, the Council on Aging has required me to limit my words to 330 words. That's a good thing for the reader. So they're what I call nuggets. 330 words, that's it. So so that kind of helps you also with some of these tools you're hearing. I have a lot of articles already that I've explained this in more depth than we have time for today. So that's the idea of the reverse caregiver exception. In general, think of this is a question I get quite often over the phone. Mom wants to move in with us. Should we rent it to her or sell? We don't know what to do. Don't rent it. Let her buy in. If she has the money, buy in. And then we can shelter the money because it's her home. In the example of a 1/3 interest in son and his wife's home, the deed gave 1/3 interest to the mom, and that's her home. It's non-countable as long as she's alive. By making it joint at her death without probate, avoiding estate recovery, son and his wife get their house back. So this is a combination of 2 very powerful tools. So the life estate deed, I have an article on my website, and it's also in the archives for the newsletter, no doubt. But what it is person, they sign a deed, they keep a life estate interest in their house, but they're giving what's called the remainder interest in their house. That has value based on the age of, let's say it's a single parent, let's say it's dad, he signs a life estate deed. He's giving a gift of the remainder interest, let's say to his 3 children or his 3 nieces and nephews, whoever he wants to give his house to when he passes away. That is a gift of a real interest. It has a value based on dad's age. Like if dad were to later sell his house, we'd have to use a table. And the older dad gets, the less value his life estate has, and the more value the remainder interest has. Plan A, dad doesn't intend to sell his house. That's the easiest example. He signs this deed. It's a gift, so it starts the 5-year penalty clock ticking. So I don't do life estate deeds if I'm told, well, dad's about to go into a nursing home. We're out of time. This is something we can't do last minute, like the Medicaid qualified annuity for poor Mr. Smith, who was so depressed. This has to be done, the life estate deed has to be done more than 5 years before. But it's a very powerful tool, it's very common. So I get people, they ask me this question, they're worried about their adult disabled child. But I tell them, don't worry, this is last minute. We don't have to do this ahead of time. We dump the excess assets, and whenever I say excess assets, I mean the amount over those magic numbers early on you heard about. The community spouse can keep $123,600. If he or she has more than that, those are called excess assets. They can be all dumped into a pool trust, which I'll explain in a minute, or a special needs trust. We also call it a D4A trust. So we can shelter it, we can do this last minute. So the main piece as a takeaway, if you ever hear people worried about that, the nursing home, my adult disabled child, I know it's another issue, who's going to take care of this person when the parent dies, but at least don't worry about Mass Health, because we can do this last minute. A pool trust is a very it's a charitable organization. We have 4 or 5 in Massachusetts. Let's say it's single Mrs. Green. She can only have under 2,000, but she's got 102,000. We can last minute dump her excess assets of 100,000 because she's unmarried. She can keep her 2,000, but she has an additional 100,000. We move it over into a pool trust. It's just some paperwork. It's not a trust in that sense. This organization will manage Mrs. Green's money, but the big piece here is we dump it in last minute and Mass Health will pay her bill. At her death, her money will be used to pay back Mass Health. Now, this won't work if Mrs. Green is in a nursing home a long time where Mass Health has spent more than 100,000. But if she's in for a short time period, you save 4,000 a month. She could pay privately her 12,000 a month on her 100,000 and then qualify for Mass Health, or put it in a pool trust, and the pool trust only pays 8,000 a month or 6,000 in some situations. So it's a way to pass on an inheritance, and we can do that last minute, this pool trust. We also use pool trust for disabled individuals, for the adult disabled child. If we don't do, sometimes we need a pool trust because there are no trustees for the supplemental needs trust, for the special needs trust for an adult disabled child. And we have the advantage of a pool trust because the social workers, staff people, they serve as trustees to manage the money for an adult disabled child, or like a Mrs. Green type person. Okay, this gentleman here early on brought up the irrevocable trust. We call them IIOTs, which stand for Irrevocable Income Only Trust. This is like the life estate deed. The first step is to sign a trust in the attorney's office. That creates what I call the empty piggy bank. Then they have to fund the trust. Let's say it's $500,000. It could be real estate, money, whatever, not retirement benefits, but everything other than that. Dump that in there, not all of it, but half of it or some. You know, we got to be careful. We don't want to put everything in this. The rule is the person who puts that money in, they're called the grantor or the donor because it's their money, their assets. They're only allowed to keep income from it. So we only want to put in assets that, it'd be like put the goose in that lays the golden eggs. The client can keep the golden eggs, keep the income, and doesn't want to kill the goose. Keep it in that irrevocable trust. But it's a very, very strict rule. It has to be very carefully drafted because Mass Health hates IIOTs because there's no limit to what we stuff in there. A person could be a billionaire, not that they would. I don't really see that. But there's no limit to what is put in there other than we can't put retirement funds in there. But the big fat rule, and if Mass Health learns, they call it the any circumstance test, if there's any set of facts that are hypothetical that could allow the person who put that money in this trust could tap the principal, then they will disallow it as an impermissible gift, and they'll require the trust to pay it back to the donor, the person whose money it was, and then it goes to the nursing home. It didn't work. So we really only put certain assets in there because it's income only. So it's a different tool, but we need to do it more than 5 years ahead. And it's not 5 years from when the trust is signed, it's 5 years from when it's funded. So if people do it, I want them to get the funding going right away. We want to snap along with it. Okay, Medicare. Medicare is, a lot of people, they kind of say it interchangeably, Medicaid, Medicare. I used to do that before I got into this area of law. That's the health insurance for people age 65 or older who have been disabled for more than 2 years. But I must talk about two. We're in the home stretch here. I got to talk about, there's two tips and traps associated with Medicare. So Has anyone heard about the observation versus admission trap? Good. And every time we start talking about it, I hear another horrible story. So I'm just going to do a little hypothetical. Let's say it's Mr. Green this time. He lives alone. He has some sort of medical situation, and an ambulance transports him to a hospital. He's in the hospital for, let's start, a few days. That's usually how I hear about this on the phone. Dad was in there for a few days. Well, what was it? 3 midnights? That's what we need, precise 3 midnights. But here's how it goes. He's in there for a few days. No one knows, a lot of people don't know about this trap. And then they say, after his hospital stay, well, he can't go home. He needs rehab. And he goes to a nursing home in Western Mass. That's how we do it around here. He goes to rehab, and that's a daily rate of like $575 a day or something. And Medicare pays up to the first 20 days. But when he gets over to the nursing home, I get the call, what? Medicare isn't paying for Dad's rehab? They told us that would work. It's because Dad he wasn't an admitted patient for more than 3 midnights. He has to pass. So if Dad's in the emergency department waiting for a room, as an advocate for Dad, do the paperwork so it shows he's admitted even though he doesn't have a room yet. People are confused because a patient is in a semi-private room. There are true stories out there. There's a gentleman in Texas. He was in a semi-private room for 14 days, never as an admitted patient. He was under observation. Medicare will not pay. He has to be admitted for 3 midnights. Then when he goes over, so let's say, that's trap number 1. The family Dad in this example has a right to appeal, but they don't have to tell him he has a right to appeal. So it can be appealed, but we're fighting that one right now. We haven't won that battle yet. The second problem is, I used to hear this all the time, and I'm still hearing this. They would say, I don't know if any of you have heard this, they would say, oh, okay, Medicare paid, let's say in this hypothetical, and Dad got his 3 midnights under his belt or more as an admitted patient. He's now, Medicare's been paying. The average Medicare is only like 18 days. So then they say, we're having a family meeting now in 2 or 3 days, and they have the meeting, and then I get the call. Dad's off Medicare. I thought it was 100 days. No, it's when the medical intervention is no longer helping Dad. They used to say, has anyone heard this? Dad leveled off. So Medicare stopped. The Jimmo case proved that was never the law anyway. It's not just leveling off. That's the improve the patient's condition standard. There are 2 more standards here. To maintain Dad's condition can keep Medicare going, and better yet, if it prevents or slows his further deterioration. That's huge, and that's winnable. I just had a case, it was this year, I can't believe it's still happening. This case, notice it came down December 2013, and we're still fighting this battle, but it's much easier now we have this case, where it was in a Western Mass nursing home. I get the call from the wife this year. She said, they said my husband leveled off. I can't believe they're still saying that. He leveled off, and Medicare has stopped paying. And I go, would medical intervention help slow his deterioration, help in any way? Oh, yes, absolutely. I said, call the ombudsperson. An ombudsperson is a state employee that they oversee a geographical group of nursing homes. So if a patient or a family has an issue, they call the ombudsperson, and they're very good. They go in and they check it out. Well, this ombudsperson out of Northampton, it happened to be, there was their region. They went right out and they solved it right off the bat. His Medicare resumed. We didn't have to appeal that one. It was like handled right away. And you will be, the patient will be given the paperwork. They say, well, medical intervention is no longer, we know Jimmo, medical intervention isn't even slowing deterioration, and so you have the right to appeal. Here's the paperwork. And there's 5 levels of appeal, but there are good resources out there to help people, but it's a long ordeal. So that's the Medicare hot topics, and then now we're down to the final a couple of slides. We have wonderful home care options in Western Mass. And the senior center here could be very, very helpful with this. I'm just doing kind of a little checklist to remind people about it. PACE, I love PACE because it's a van pickup model usually. That's how I know it. Monday through Friday. It's a nursing home by day. So it works best when there's a spouse at home who like needs a break. The van comes 8:30 and they go. There's a doctor on premises. We have one in West Springfield and one in downtown Springfield. Very nice facilities. And it doesn't have to be 5 days. It could be 1 day a week and so on. And I always encourage people to go visit. Or the Springfield one is very nice. They're both very modern. And then we have other programs too. The Frail Elder Waiver is something you go through the different agencies around, and I can give you more information about that because we really are pretty much out of time here. But there's a lot of home care that my clients aren't knowing about, and so I just want you to get the word out. Start here, and you'll get some really good information about where to go next and for helping pay for home care. Aid and attendance. This is for our veterans and our veteran spouses, widows included. I met with a client not too long ago, and she needs help at home now. Her husband died 20 years ago. He was a veteran. I said, you can get aid and attendance. So our widows of veterans don't know about it. But it's a check that comes in. She's going to get, it's now for a widow of a veteran, about $1,100 a month. And that helps her. She needs all the help she can get. It's like a check that comes in, and it's almost like no strings attached, as long as it's for her. And it follows her. If she has to go to, and our veterans too, the veterans get a bigger check. And if the veteran or the spouse or the widow of a veteran has to go to assisted living or a nursing home, it follows them from home to assisted living to the nursing home. So that's a very important program for home care. It takes, if you go through your veterans counselor, it takes like 1 year and 4 months for it to kick in and you get retro. But there are also some individuals, some private individuals, not those ones that advertise on television, never go there. But if you want to call me, I can give you some names of the people who are very legit and can get it done in like 4 to 6 months. And one in particular doesn't charge for that at all. Another one charges maybe $500 to do it faster than going through the veterans counselor. So that completes my presentation. You've been a great audience. Thank you.